how Act 250 works in the real world. So let's take 5 minutes and let Ed get set up, and please.
Oh, no. I would have filled it. I would have been involved. I quit.
Let's get started. Thank you.
Thank you.
For your patience.
For the record, my name is Ed Stanak, and I'm a resident of Bear City. And thank you for the opportunity to provide some insights on the administration of Act 250 on a day-to-day basis. I was hired under the administration of Richard Snelling to work for Act 250 way back in June of 1980. Peg Garland was the chair of the Environmental Board at the time. When I began working for the program, we had what was called a roving coordinator. So for the first 2 years, I had the benefit and the pleasure of working with district commissions from Newport to Brattleboro, from Rutland to Bradford, getting a full perspective on how the program was being administered. 10 years in to Act 250 had already been in action for 10 years. Subsequent to that, I spent the rest of my career, well, 30 years, administering Act 250 in District 5. And District 5 consists of Washington County, Lamoille County, and a few towns in Orange County. So it covered the big ski resorts in Sugar Bush Valley, the Stone Mountain Resort. We also covered mining projects, shopping malls, and a couple of logging projects over 2,500 feet in elevation. Some of those projects in terms of scope included the Stone Mountain Resort, $300 million expansion project. But it also included working with people, for example, who were proposing booths at the Lamoille County field days up in Johnson, Vermont. And it also involved working with mom and pop projects. You know, someone who was trying to put his son or daughter through UVM, and they needed some additional capital for tuition. And I'm talking here about small-scale gravel pit projects. I always assumed my responsibility was to work with the applicant as well as with the parties to have a successful experience going through Act 250. I'm still involved with the program to the extent that I get calls from folks around the state who wake up one day and something's being proposed next to them. So I do some pro bono work, helping out adjoining landowners and members of planning commissions trying to figure out projects. And I still remain in contact with my former peers, the other district coordinators who run the program. I'm sure you've heard a lot about the origins of Act 250. I think a lot of it is in the essence of the legislative statement of findings, both from 1970 and 1973. There's tons of stuff written. The professor just before me referred to Professor Richard Brooks' treatise on Act 250. This is volume 1 of 2. This is soup to nuts and everything in between. You know, in a very small nutshell, some of the commentators, legal commentators, trace Act 250 back to the common law theory of nuisance. You know, you shall not open up a tannery, you know, which is going to impact a neighbor next door. Some of the most ancient cases on land use law dating back to the 1600s dealt with things like tanneries. But also people talk specific to Vermont that, you know, some of the environmental ethic which became Act 250 can be traced back to the exodus from Vermont in the 1800s after the initial depletion of the soils from the initial settlement era. Some others point to stuff that was going on in the creative fashion in Vermont for reforestation after people began to recognize the significant impacts of erosion and sedimentation of the streams in the early 1900s. So, you know, it didn't just come in a dream to Dean Davis. There was a lot of background to how Act 250 evolved. I was lucky enough, as I said, working for the program in 1980, that I got to meet some of the original folks that put it together. Jonathan Brownell, John Hanson, an attorney from Rutland Way. You know, and a lot of them talked about how Dean Davis and the crew, and these were all lawyers, they really did not want lawyers involved in the district commission level. There's an expression which they said, but I've never found it written anywhere, that Dean Davis thought that Act 250 should be administered on the proverbial Cracker Barrel in the general store. You know, it should be fact-based, fact-oriented, and as I mentioned in a few minutes, there was this other thing called the Environmental Board, such that if there were going to be appeals and legal issues, that would all be straightened out on the appellate level. Jonathan Brownell, who I mentioned was one of the folks that put Act 250 together, a few years after I began working for the program, was hired by some neighbors to oppose a project in Stowe, which became known as the Landmark Meadow. You may be familiar with that. And he was in a really difficult situation because he was hired to zealously represent his clients, but he kept saying, even during the hearing, I really shouldn't be here. You know, this should be a fact-based consideration of the criteria, keep the lawyers out of it. But that's ancient history. That's a little bit commentary on the origins of the program as it was related to me. As I mentioned, I always thought, and many felt, the Environmental Board was the core of the program, and not only in terms of the day-to-day administration of the program and supervision of the state employees such as myself, but the Environmental Board, in its appellate decisions, issued precedents. And these precedents are the glue which ensure the consistency and the continuity of how Act 250 is administered. I always assumed it was my responsibility when people came into Act 250 not to have a deer in the headlight experience, whether you're an applicant or a neighbor. It was my responsibility to make those folks aware of these Environmental Board precedents, which are still with us to this day. In 2005, when the General Assembly passed the major permit reform legislation and eliminated the Environmental Board, it specifically said in statutory language that the Environmental Board is obligated to adhere to all those precedents of the Environmental Board. So when people say Act 250 is a subjective experience, it's just based on the biorhythms of the district commission on a given day, that's not correct. If Act 250 is administered in a proper way, it's firmly anchored in those precedents of the Environmental Board. Now you can find these online, and I'll be happy to provide citations and stuff as I ramble through this for the use of the community, but there are these things called the e-notes. And the e-notes are available on the Natural Resources Board website. And if you take a look at the e-notes, it's this lengthy outline of process under Act 250, the rules of evidence, but you can scroll all the way down to the criteria of Act 250, and you can see the names of the different cases. So, and when people begin to have this metaphysical experience, what is undue water pollution? Because that's what the statute says. There shall not be undue water pollution. What does that mean? Well, the Environmental Board had to figure that out as of 1971, when the first appeals began to surface. So when you go to those e-notes, you can also very easily get into the Environmental Board decisions and understand, how Act 250 and the criteria were interpreted. So how does it work on a day-to-day basis? The beginnings of Act 250 are jurisdiction. The burning question of our times, do I need to get a permit? And jurisdiction basically in 10 VSA 6001 divides subject matter of land uses into development and into subdivision of land. You may have heard from others the testimony about so-called 1 acre and 10 acre towns. 1 acre, 10 acre towns simply being that the legislature decided back in 1970 that if towns had both zoning and subdivision regulations, they could pretty much take care of development up to a certain scale. So no Act 250 jurisdiction in those towns unless the property on which the project was pursued was larger than 10 acres in size. By process of elimination, if a town chose not to have zoning, subdivision, no local control, 1 acre was the trigger. And this is an important concept because, as I mentioned in a few minutes, throughout all the Environmental Board jurisdictional decisions, they felt, and the Supreme Court affirmed this, that it's very important to have bright line definitions of jurisdiction. Bright lines, something that somebody could just decide jurisdiction and there's not going to be a contested case just simply trying to figure out if somebody needs to get a permit. So again, Act 250 divides it into development and the subdivision of land. And in the most simplistic analysis, the subdivision of land is 10 or more lots within a 5-year period, although there are some nuances to that over the years. We used to have a provision of Act 250 called the road rule, which was repealed in 2005. I thought that was unfortunate because the road rule really helped plug a hole in terms of development. I felt in towns like Waterville and Belvedere. We're talking here about those mountainsides, 1,500 feet, 2,000 feet high. Those towns, when I worked, never even had sewerage ordinances in place. If you can believe that. They probably do by now, I hope. But the point here is that the road rule, which said that a permit was required if somebody was going to sell parcels of land and you had to construct a road either over 800 feet in length or provide access to more than 5 parcels. That really helped to scoop up some of the most threatening development, maybe that's the wrong word, but development in these high elevation settings came in a lot under the road rule. But as I said, that was repealed in 2005. So back to jurisdiction. The vast bulk of jurisdictional determinations, I would say 90% of them, are done in a form called a project review sheet. A project review sheet is this two-sided piece of paper. It goes back to the days of the goal being one-stop shopping. Where could an individual in Vermont go to find out whether she or he needs to get a permit or permits from the state? And so this was set up years ago in the district offices, so someone could come in and these project review sheets would simply be checked off, Act 250, yes or no. That's 90% of the cases were decided like that, a black and white decision on whether or not you need to get a permit. Those other 10% of the cases is a permit required under Act 250, resulting in what's called jurisdictional opinions. And jurisdictional opinions were essentially lengthy letters, half of which describes the facts going on, and then the second half describes the precedents and the statutes and the rules to reach a conclusion whether a permit is required. A lot of those jurisdictional opinions, as an example, dealt with substantial change. You might have heard this phrase, substantial change inside Act 250 deals with the concept of whether or not an otherwise pre-existing project could do something now, which requires an Act 250 review. Pre-existing under Act 250 is defined as something that was in existence prior to 1970. So as an example, somebody had a gravel pit on the back 40 of his or her farm since 1958, and they were just pecking away at it. And now someone was coming in with crushers and screeners and stuff. The question would be, well, is the introduction of all that heavy equipment and an increase in an extraction rate a substantial change? So there's a good example of something that would just simply not be checked off on a piece of paper. The coordinator would issue these jurisdictional opinions. Again, the district coordinated by statute decides whether or not someone is required to get a land use permit. And we go again back to those environmental board precedents. I know the committee is grappling with new definitions of jurisdiction. It certainly is a new era. Again, the era in which Act 250 was created was many towns had no sewerage ordinances and no zoning and subdivision. That has changed. In fact, that is reflected on the decrease in the amount of Act 250 review of development these days. The estimates are that only about 30% of all development and subdivision going on currently in Vermont comes under Act 250 jurisdiction. 30%. It used to be 50, 55%, but over the decades, as towns have adopted more local ordinances, what have you can see there's been a diminishment in Act 250 jurisdiction. Again, jurisdiction is the 1 acre, 10 acre towns, 10 or more lots. But, I think we would all might agree that now we're in the 21st century, towns are doing a thorough job of the review on certain impacts. The focus perhaps should be on those finite natural resources. I used to do a lot of Act 250 one-on-one presentations, and I always said that the purpose of Act 250 was, number one, it's a permitting process. Contrary to what people hear, the denial rate is very low. I think 5 or 6%. In my entire career, I was thinking in preparation for today, I was thinking about the number of denials that I offered on behalf of a district commission, and I couldn't come up with more than 15 in 32 years with all the commissions I worked for. So the purpose is not to obstruct growth or stop development, it's to ensure quality development subdivision and protect those finite natural resources. So my suggestion is perhaps the new jurisdictional triggers in the 21st century would be focused on those finite natural resources, which by definition, there's only so many left. I'm going to leave this with the chair. This is sort of a collector's item. Len Wilson, who was the chair of the Environmental Board, authored this in 1983. And this provides a few real good insights. Number one, a perspective on why did the effort to adopt the land use plan crash and burn. This is from people that were there at the time. But it also talks about the early era of Act 250, the first cases that went to the Supreme Court, when everyone was trying to find the compass. How is this thing going to be administered in an efficient way and not be a burden? But again, it talks about the jurisdictional triggers and those resources. So again, back to bright light on jurisdiction. There should be language in statutes if there are new jurisdictional triggers which would not unnecessarily result in contested cases, simply to figure out if somebody needs to get a permit. And it probably should be anchored in compelling state interest in those finite natural resources and compelling state interest in strategic locations. Many of us feel that a lot of those finite important natural resources are now, I guess the buzz phrase is, up along those ridge lines. There's a lot of different schools of thought as to what's the definition of ridge line. Come back to that in a minute. But there's also strategic locations down in those valleys. You know, if you think of, for example, on habitat functions, where moose would go during certain feeding seasons. We think of prime egg soil, which I'll come back to in a minute too. So again, jurisdictional triggers in the 21st century, when I think of what could they be, I think of what are the compelling state interests for future generations. By definition, the natural resources that remain are finite, and there are strategic locations which should be protected.
I have a question for you. Was the 800-foot road rule, in your mind, a bright light? Like, was it pretty easy to administer?
It was. We used to, in a dark human way, sometimes say, when is a road a road? When is a road a driveway? When is a foot a foot? You know, we used to see a lot of things that were 799 feet long. Do you measure the cul-de-sac up to the middle of the cul-de-sac, around the cul-de-sac? But I think the direct answer is it became pretty black and white after the initial cases. You know, when is a road? When is 800 feet, and what requires a permit?
Representative Smith.
Yes, I was just wondering, you were talking about finite natural resources and you mentioned egg soils. And I was thinking of a lot of the Act 250 projects around me. You have to protect those soils, and yet they're not used for anything. And so I'm wondering if we're just wasting and squandering those soils because of where they're located and not really saving an overall portion of hybrid, or not hybrid, but ag soils.
That's a great question. You know, it doesn't make sense to preserve 6 acres of prime ag soil that might be located in Barry City. But I will say this, you know, back in the 1980s, when a lot of these questions came up, under criterion 9B, which deals with primary agricultural soils in Act 250, a lot of the controversy back then was, in terms of threshold questions, what's the size of a piece of land even big enough to be considered as primary ag soils? You know, should it be 15, 20 acres? And again, in that era, you know, when you thought of agricultural use and farming in Vermont, almost everybody thought of what? Dairy. And there were a lot of hearings back then to decide before the district commission if the definition of prime ag soils, which is in 10 VSA 6001, I think it's subsection 19, does that definition apply to the soils? We had testimony from both the Department of Agriculture and other organizations about how the future in Vermont would be small-scale farming, vegetables, fruits, and stuff like that. Well, they were laughed out of the hearings. They said it would never happen in Vermont. You know, it's dairy, this little stuff isn't going to happen. And people would come back in subsequent hearings and different projects, and they would start producing maps of the population bases in New York and Boston and Montreal, and how Vermont is equidistant from them, and we could be exporting food. And where are we today? So all those small pieces of prime ag soil, it's a mosaic or a jigsaw puzzle. But I agree with you. You know, one of the major policy considerations is, or should be, or has to be, the location of that parcel of land. I think criterion 9B, I'm sorry.
The location of it, but also the compatibility and the ability for those small parcels of land to be used for agricultural purposes. You know, in different mix, whether it's an industrial complex or, you know, any other thing. You know, sometimes there's compatibility issues. And I'm just wondering if because of some of those things, we're squandering those soils.
Yeah. Well, I think one response is the legislature has already, in a way, gotten its hands around parcels of prime ag soil which may not be used for that use. And where I'm going with that thought is 10 VSCA, I think it's section 1693, deals with mitigation of the development of prime ag soils. So the first goal is protected prime ag soils, go through the sub-criteria, but the legislature has decided that there are instances where it really might not make sense to preserve that 6 or 7 acres of prime ag over here in isolation in the vacuum, and instead we go to off-site mitigation. So I'm agreeing with you, that there are probably parcels which it would make no sense to segregate out reserved for prime land use, because they probably will not be used. The legislature recognized that and carved out that position about off-site litigation. So back to the process. So jurisdiction, project review sheet, one-stop shopping, well-oiled machine for years and years and years. When do people need to get permits? And we also, some of us felt, we should regionalize even more, that people from Agency of Natural Resources that do the wetland program and the stormwater program should be regionalized. So people would not have to go to Mecca. It used to be Waterbury, now it's Montpelier, in order to find out if you need to get something from wetlands or stormwater. The more regionalization, the more user-friendly for the people that are going through the process. So let's say someone is required to get a permit. How do you get an Act 250 permit? Again, the district commissions, who are the quasi-judicial members of the quasi-judicial process, they are the ones that decide if a permit is issued and what conditions are attached, not as bureaucrats. We simply staff the district commission and provide the support. The district commission members make the decisions on property rights and the use of that property.
Thank you for bringing up that point. My question is in regards to calibration. You described the various resources that we as lay people could go to on the website to get, or even perhaps employees of the Natural Resource Board use to help determine or look at kind of the history of prior cases to help inform them. But how do they calibrate the decision making from one district to another to, again, further the consistency and moreover try to emphasize the point that the vice chair was talking about in terms of flexibility or predictability. That calibration is critical for that predictability part of that.
I agree. So I'll begin by saying again that the Environmental Board precedents are the glue, is the glue which provides consistency and continuity, but easier said than done. From the beginning, if you read the stuff that's written, they will say, or they have said, that it was always intended to be a regional process that recognized the different characteristics of the different regions of the state. Sometimes you say, what does that really mean? And so we would see that district commissions, euphemistically say the big league commissions, District 2, District 4 is Chittenden County, District 2 is the area around Brattleboro, District 5, areas that do the ski areas. It's a lot of experiential learning by these district commission members. The volume of the work gets them up the learning curve. On the other hand, you have district commissions from the islands of Lake Champlain or up in the Northeast Kingdom. The nature of the beast is such that over the years, low volume of applications, right? So in terms of volunteer citizens serving on these commissions, that is a question to ensure consistency and predictability when they haven't had that opportunity for experiential learning and actual applying the law. The answer is training. In my view, there used to be a lot more substantive training of commission members back in the day when there was an environmental board. There were annual meetings in which there were substantive trainings under different criteria on procedure and process. But even before someone went on to a district commission, once they had just been appointed by the governor, there were these 6 or 7 hour training sessions for them. I know that even when I left the program way back in 2011, this was starting to erode away. Perhaps it's been improved, but on the topic of predictability, I think one important thing would be strong training of the district commission members. It is indeed a statewide program. There might be some latitude for regionalization, but it has to be a level playing field from district to district. So if somebody needs, I'm sorry.
Would you write that into the law?
I don't know if it has to be written as a statute. It could be done in rule. There used to be a lot more active rulemaking by the Environmental Board than we see under the Natural Resources Board. This body would sometimes give its sense of direction to the chair of the board, and the board would go into action in terms of writing rules. So perhaps to ensure predictability or training or things like this, I think rulemaking might be a more efficient way to get where we So if somebody's required to get an application, there are statutes, but a lot of the substance are in the rules in terms of what is required. Site plans, there's this questionnaire form called Schedule B, sort of like this mystical name. And it simply is a bureaucratic term because way back when, even before I was a bureaucrat, you know, they had an application package that had in it Schedule A, Schedule B, Schedule C. Nobody even remembers where those names came from, but Schedule B stuck. So if you go to the Natural Resources Board website, you can see Schedule B in its full glory. It's this multiple-page questionnaire, and it's an effort to solicit from the applicant information under the criteria, so that the district commission then goes into the hearing, or if the project's reviewed without a hearing, they do so in an informed way, having had the information from the applicant under the criteria. So application page, Schedule B, site plans, supporting documents. For example, if it's a residential project, do you have a letter from the local fire department about their ability to serve the project? That would be a supporting document. And things of that nature. So when the application is submitted, it's given to the district office, and the first step that's taken is the determination that the application is complete. That's a function of the district coordinator, the gatekeeper. So the application, in terms of determining if it's complete, it's not up to the coordinator to decide if there's enough information here to get a permit, but rather, is there enough information provided under the criteria such that the review would be efficient and would move along in a productive way before the commission. So for example, under that Schedule B, there's a question for streams 1E, and if somebody fills out the form and you come to the questions about stream and you see NA, well, that's really not an answer, NA, not applicable. So we would ask for a little bit more information. Well, is there a stream on the property? What is the proximity to the stream? So stuff like that determines if an application is complete. On some of the bigger projects, the Stone Mountain Resort project, which is again a $300 million project, that application was ruled incomplete 4 times, soliciting more information because we knew that was going to be a very complicated review on water quality and traffic, etc. I thought if I ruled it incomplete the 5th time, I would do so at my peril. So that was my record for ruling applications incomplete 4 times. And they got their permit. You can go up there today and see the hotel and so on and so forth. So when the applications go to the district commissions, the district commission members, who are all volunteers, they get paid a per diem. And in fact, I think I'm still correct in saying they really don't get paid for the time they put in for reviewing the applications, which is mind-boggling because some of them put in a lot of time doing this stuff. Per diem really only applies to hearing time for a project that's had an actual hearing. So we would give the applications to these volunteers on the district commissions and they would review it. The threshold decision is the project going to be processed as a minor or is it going to be processed as a major? The most simple explanation, what is the difference? The majors are the ones which have hearings and the minors are the ones which, at least out of the starting gate, are processed without a hearing. The commission drafts a proposed permit, which the applicant sees, the statutory parties see. The statutory parties are the town select board, the planning commission, the regional planning commission. They all know what that permit's going to look like. And most importantly, notices go out. And so the notice goes out and the neighbor or someone else could request a hearing. That gets us into the concept of party status. Party status is the heart of public participation in Act 250, which has been there from the beginning. And over the years, the legislature has refined the definition of what qualifies an individual to become a party to Act 250. The standard right now is particularized interest. You have to have a particularized interest under one or more of the 10 criteria. What is a particularized interest? Well, generally speaking, it's an interest or a potential impact under the criteria that would be more than that for the general public. So a good example is a big old Victorian house is going to be renovated into a restaurant, and they're going to have to put in a parking lot. And Mrs. McGillicuddy lives next door. And Mrs. McGillicuddy says, "Oh, I don't have a problem with the restaurant, but the parking lot and those headlights, they're going to be shining in my window." That's a legitimate concern under Criterion 8 of Act 250, which deals with aesthetics. So Mrs. McGillicuddy's particularized interest in that example would be more than that of someone of the general public, because she's right there with the potential for impact. There are other cases which have gone to the Supreme Court which talk about uses of rivers. There was a famous case down Bethel Way, where a project was proposed on the shores of a river, and an individual who grew up in that town and canoed and fished and used that river for 35, 40 years was able to qualify for party status because his use was more than that of just the general public. You know, my experience was, in all honesty, it was very rare to see someone ask for party status who wanted to stop the project. People do not come into Act 250 for the most part and say, I'm opposed to the project. They came in because they were trying to find out about the project. They were trying to identify how they might be impacted. I'm not going to say that in the big league, you know, we had the era of the big shopping malls up in Williston and stuff like that, that there weren't citizen groups that had a whole bunch of policy reasons why the project should not go forward. But those were the exceptions. Those were not the rule. Most people who participate in Act 250 are there because they're trying to get some mitigation or a minor redesign of the project. So 75% of the applications these days, 75% of them are processed as minor applications, which means there's no hearing, and because there's no hearing, there really is no public participation. Again, keep in mind, public participation means that thing called party status, an opportunity to present information to the commission, to ask questions of the developer. If there's no hearing, there's no forum for public participation. Now, there's a lot to say there about whether the rate of 75% is a good thing or a bad thing. I will say one thing, that some of us old dogs are concerned about the increasing use of the administrative amendment process for permitting of projects, changes to projects already under existing permits. And all this song and dance about amendments to permits are found in Rule 34. So if you go to the Act 250 Rule 34, you will see it talks about this kind of amendment, that kind of amendment. Rule 34E deals with these administrative amendments. And administrative amendments are supposed to be only things which are mere record keeping. I talked to some of my peers, and I understand there was one project processed just within the last couple of years. I think it was a $28 million improvement to a wastewater treatment plant, which was done as an administrative amendment. That knocked my socks off, because if you go and try and figure out, okay, what qualifies an administrative amendment, it's in the rule. And more to the point, minor applications are set up by 10 VSA 6025, and then you go to Board Rule 51. So what I'm saying here is, I guess I'm expressing a concern that in the name of expediting things, we're seeing a drift towards projects being processed as administrative amendments when perhaps they should be minors, and perhaps we're seeing projects processed as minors, but you're better off going to a hearing. Again, in my experience, you know, sometimes you would never hear from anybody about a concern about a project until you would turn on the tape recorder and convene a hearing, and then the neighbors would come in. You know, people are very nervous about this thing called government. They're very nervous about, you know, being the one that's going to be, you know, blowing the whistle on the guy next door. They don't want to rock the boat. So they're very reluctant under this song and dance of minor applications to make a request for a hearing. My experience was they're not cheapish about coming to a hearing if there's going to be a public hearing, right? Everybody goes to town meeting in Vermont. We're all used to some sort of interaction once there is a governmental public hearing. So applications, the first step is it going to be processed as a minor, or is it going to go to a hearing and be processed as a major? I know this is the 4 o'clock club, so I'm doing my best. I'm sure I have a joke. So, you know, in terms of being user-friendly, I always used to tell people, you know, look, if you're freaking out over Act 250, don't panic, call Stanak, you know, and help you figure out how to go through the process. And that was a sincere effort for applicants and parties alike, how to figure out, you know, this thing called the bureaucracy.
That's why we called you.
Call ahead and get ahead. Now, Act 250 also has this interaction with other permitting processes in Vermont. The big ones are the municipal permitting process and the permitting array of permits under the Agency of Natural Resources. In Vermont, the General Assembly passed over decades ago the legislation which enables towns to have zoning and subdivision regulations, 24 VSA Chapter 117. But not all towns are equal. What do I mean by that? Some towns still have zoning boards of adjustment. Some towns have development review boards. Some towns, but not many, have the Cadillac version of development review boards, which are the towns which adopted Municipal Administrative Procedures Act, which you can find in 24 VSA Chapter 36. What is that all about? Well, if your town has a development review board, and you go through the process under the Municipal Administrative Procedures Act, according to the legislature then, your town decision creates a presumption under parts of Act 250. So here's an answer to some of these questions. What weight can a town have in the Act 250 process? The answer is a developer can come in and simply lay that town permit on the table if it's a DRB that's gone through the Municipal Administrative Procedures Act, and there's a presumption of compliance with criteria 6, 7, and 10 of Act 250. Bingo. I called one of my peers yesterday trying to get the latest and greatest, and his guess was the number of towns that have gone through MAPA, Municipal Administrative Procedures Act, approximately 6 towns have done that. That's been a provision in the law for 15 years now. So there's some sort of message there about why aren't the towns doing this? Maybe there's multiple messages. Over here we have the Agency of Natural Resources permitting entity. The law has always been set up, 10 VSA 6086 small b, has always said since 1970 that if there are other permits from other agencies, the Environmental Board shall set up a process so those create presumptive proof under some of the criteria of Act 250. The Environmental Board went ahead and promulgated Rule 19. So if you go to Rule 19, there it is, chapter and verse, about what A&R permits create that presumption for stormwater, discharge permits, wastewater disposal, water supply, wetlands, so on and so forth. If you get one of those permits, you lay it on the table, and that swings the scale of justice in favor of the applicant. In theory, the applicant wouldn't have to put on any evidence before the district commission because they have that presumptive value. But the important thing is the legislature also had the wisdom to say that was going to be plugged into what's called, and the Supreme Court affirmed this, the supervisory role of the district commission, the fail-safe review of those presumptive permits. So a district commission does not come in and just, in a cavalier fashion, cast aside those A&R permits. They recognize that there were trained scientists and technical people that put a lot of effort into those technical reviews. It has to be evidence. It has to be either direct evidence or cross-examination, which bursts the bubble, that there was either some regulation on file or the agency wasn't aware of something, and so the presumption then is rebutted. It doesn't mean the permit is denied under Act 250, it just means the applicant then has to present evidence instead of the presumption. Now, my whole career with Act 250, how many projects were there presumptions of A&R permits? I think it was less than 20. Less than 20. I look back in hindsight, and I'll give you one example of those. In the 1980s, the Trapp Family Corporation, after the lodge burned down, they were building a new lodge, and they wanted to get into timeshare units, so on and so forth. They needed somewhere to put the sewerage. And so they went through this whole process of designing a big wastewater treatment plant that would be plunked down in one of those meadows, and it would treat the effluent. But it would not then be put into subsurface disposal fields. It would be, the treated effluent would be discharged into the little river, right at the river's entry into the Waterbury Reservoir. Now the A&R issued a discharge permit approving all that. Folks came to the district commission and said, well, district commission, and they proceeded to methodically provide the commission with evidence about the long-range planning uses of the Waterbury Reservoir for recreational use and fishing. They pointed out that the T's were not crossed, the I's weren't dotted. And there is a case where the presumption was rebutted. The applicant did not meet the burden of proof, and the permit was denied. The world came to an end the next morning on the 5th floor, and let everybody know they were unhappy about this. But here's the happy ending to that story. They put in some temporary on-site disposal fields. 10 years later, Stowe expanded its municipal treatment plant and put in municipal infrastructure. And Johannes von Trapp told me, in hindsight, that was the better outcome. because that company did not have to have the responsibility of running a wastewater treatment plant, maintaining it, so on and so forth. It went to the right disposal point, which was a municipal system. And it also was done in hand in glove with very methodical planning in Stowe and zoning, so that that extension of the sewer line up to the trap hill did not result in sprawl. So there's an example of a presumption being rebutted, very rarely done. I think that's a strength of Act 250. That there is this fail-safe mechanism, extremely rarely used, but when it has been used, it's really been good for the public interest. Everyone's hanging in here, right?
It's Tuesday, it's our Monday.
Yeah,
We're awake.
that's true.
We're gonna top it.
So the other thing that comes up with Act 250, okay, I file my application, it's like now time waiting for Godot. When am I going to get a permit? You know, this process never ends, delays. It's not timely. Well, the legislature in 10 VSA 6084 had a lot to say about performance, you know, and deadlines and stuff like that. And the Environmental Board also carved out for us bureaucrats performance standards. So many days to get things done. Now you can see this snapshot in time, and there's an appendix in here back in 1983, what the processing time was for applications. And this body, the General Assembly, by law, I think at the citation, by February 15th every year, you are to be given an annual report by the Natural Resources Board on the number of applications processed and breaking it down in terms of how long did it take to process. So I don't know if it came in yet. I didn't have a chance to look online today, but it was due here February 15th. So the point is, how long does it take to go through Act 250? There's all this proof in the pudding. By definition, if 75% of them are going through as minor applications, relatively speaking, they're whipping through the process. Most of those minors are over and done within 60 to 90 days. My experience was most of those applications that are processed as minors were actually done in 10 days, the minimal notice period. And then I had to keep it in the file cabinet because we're waiting patiently for the A&R wastewater permit or the A&R stormwater permit or some other thing. So when you drill down into the details of specific applications, it's very interesting and revealing to see when was the Act 250 process done, and then the commission had to wait for what else before they could issue the final decision. Why? Because the law says, remember, those A&R permits create the presumptive proof. So the commission has no way of concluding there's no water pollution until they get that A&R permit, put it in the file, issue the Act 250 permit. Now, I also want to be honest and say, well, what about those other 20-25% that go to hearings, the big, complicated cases? I'm not sure if every district did that, but I can tell you in District 5, for every large project that went to hearing, every one of those decisions on page 2 or 3 had a recitation of the procedural history. The date the application came in, the date it was ruled complete, the date it went to the commission, the dates of the hearings, the date we got the responses from the applicant, the dates the commission deliberated. It's there, chapter and verse. And I will mention a specific example because I understand my former brothers and sisters from V-Trans feel that highway projects should be exempt from Act 250, perhaps because of expense and delay. It's quite revealing if you read the District 5 decision for the Route 2 reconstruction project in Marshfield and Cabot. And you can see for yourselves, if you read that decision, well, what actually happened in terms of the length of time it took to process that application, where were the delays, and actually some interesting decisions there too about the off-site plan for wetland mitigation. So I use that as just as one example. Are there delays? Absolutely. Is Act 250 a perfect process? No government process is perfect, I can tell you that. And I'm a former president of the Vermont State Employees Union, and I'll tell you, not all government employees toe the line. But, you know, Act 250, I would say, is better than most in terms of meeting the deadlines established by the statute. So timeliness, delays, denials, the statistics speak for themselves. Only 5 to 6% are denied. Now, we often hear the comment that, well, okay, that's easy to say. What about all those other ones that get permits with all these draconian conditions that the developer just throws in the towel because they just can't meet the permit conditions? The vast majority of conditions, and again, here we're only talking about the 25% that go to hearing, okay, if you can follow the bouncing rule. 75% of them that are gone as minors I wouldn't say they're no-brainers, but there's no controversy, right? The applicant sees the proposed permit for a 10-day comment period, and they're all happy. So what I'm addressing here is, does Act 250 strangle projects by unreasonable permit conditions? That's the 25% that actually go to hearings. In those cases, you know, it's very rare, it's extremely rare for an applicant to be hit with a condition out of the blue. So many of those permit conditions are the result of an effort at dialogue with the applicant, either in the hearing process itself or after each hearing, recess memorandum are issued. And the recess memorandum are basically the commission's, okay, here's the shopping list. We had a hearing, here's the shopping list, here's the light at the end of the tunnel, here's what we're just waiting for. And they would welcome proposed permit conditions from the applicant and from the parties. So, you know, the school of thought that projects are killed off by, you know, expensive, unexpected permit conditions, I can't say it doesn't happen, but it really is not the rule. Most people, you know, go into the process. A couple of comments about some of the criteria. Depending who you talk to, there's either 10 or 28 criteria in Act 250. And I'm saying that in a facetious way because if you go to criterion 9, there's maybe one criteria, but it also has subsections A through L. So you add it up, and I think, I don't know, I forget, it was like 27 or 28 criteria, to be really honest about it. Criterion 1 deals with air and water pollution. I often find that criterion 1A is a sleeper criteria. It's called headwaters. But if you read the definition that the legislature put in there way back in 1970, it expressed its sense of concern for elevations above 1,500 feet, shallow soils, steep slopes, small watershed areas, places where there are aquifers for water supply. I think today we call these ridgelines. And today we know from testimony over the decades from wildlife biologists that these same areas are the areas where a lot of the important habitat functions are in Vermont. So I wanted to throw out on the table today criterion 1A. And I wanted to mention some environmental board precedents. Jumping back a few minutes ago to the bright line of jurisdiction, I think of an environmental decision named Blodgett, an environmental board decision known as Study Group. I'd be glad to get you these decisions so you can understand, well, what was he talking about at 5 o'clock that afternoon about the bright line on jurisdiction. So bright line on jurisdiction would be the Blodgett decision in Stony Brook. But back to headwaters. There's a great decision by the Environmental Board in Waitsfield called the Kissel decision, K-I-S-I-E-L. And the Kissel property was at between 1,500 and 2,000 feet in elevation. They were going to put in 5 large luxury homes up there. The town was not happy with it, but it couldn't get its hands around it because of what it had or did not have in its local ordinance. So this all played out in Act 250. The District Commission issued a heavily conditioned permit. It was appealed by the town and others to the Environmental Board. The Environmental Board denied the permit. But I wanted to mention Kissel, because if you read Kissel, and the Environmental Board decisions are divided in 2 parts. All the findings of fact, reciting the evidence under all the criteria, and then the second part of these decisions are called conclusions of law. And the conclusions of law are where the decision makers apply the law that the General Assembly wrote to the facts of the case. So Kissel to me is the poster child, in my humble opinion, for a lot of the issues now about these high elevation settings. Kissel happened 20 years ago. Kissel was appealed to the Supreme Court, but only under criterion 10 for the town plan. And then they won for the criterion 10. But by the time it came back to the District Commission, there was a lot of stipulations, a lot of agreements and stuff. So it never really got back to the commission to deal with all the substantive issues for a bunch of complicated reasons. But I would encourage reference to the Kissel decision, because the Kissel decision I always thought was a great roadmap as to what the potential impacts are, what the interface is with things like Vermont water quality standards. You know, all the bells and whistles that have evolved over the years, I think a lot of it's there in the Kissel decision. Yeah.
Did they end up building? I can answer that question. We just heard the presentation, the great success story. 2 houses were built, but the rest would conserve. That was the presentation we heard earlier from the Sydney Carr talking about that. The Scrag Mountain project conservation. So it's
You know, and that's another good example too of how the process in Vermont has really evolved in a wonderful way. I mentioned a few minutes ago the so-called landmark meadow case up in Stowe. This is if you go from the village of Stowe up to the mountain. And at one point you come to this big sweeping curve. If you're driving up to the mountain, big meadow on the right. Ray Ramsey from Maine, who built motels all over New England, was going to build a big motel right in that meadow. And it was denied a permit. And I only bring that up because as a proverbial movie went ahead over the years, that also came under a land trust. And so it's now known as the landmark meadow, and it's preserved forever. Because the issues were identified and hashed out under Act 250, and then other members of the community and other resources went to work and preserved it. I always thought that's a great success story, and so too was the Kissel case. Just a few more examples of criteria. Criteria 5, 6, and 7, which respectively deal with traffic, impact on schools, impact on municipal services. From the beginning, the law has always said, no matter how unreasonable the impact would be on traffic congestion or safety, impact on schools, impact on municipal services, no matter how unreasonable the impacts, a permit cannot be denied under those criteria. Instead, the district commissions have to come up with permits to alleviate the unreasonable burdens. That's where a lot of the creativity does take place in Act 250. Trying to come up with permit conditions, which allow the project to proceed, but at the same time protect the public interest. Now, easier said than done. I can think of one case which I think played out in, I want to say Addison County years ago. It was a shopping center, and as I remember the facts of the case, there were traffic signals required and stuff like that, and the applicant was less than enthusiastic about doing it. So boiling the fat off of it, a permit was issued, but the permit condition basically said, you cannot commence construction on your shopping center until somebody, we don't know who's going to do it, improves such and such a length of road, traffic signals are installed, so on and so forth. So there's the permit condition. You have a permit, but you can't commence construction on the shopping mall until the infrastructure is improved by someone else. Threading the needle. I already mentioned criteria 9B as a success story. I think Act 250, as we look back on the 50 years now, has been the workhorse in Vermont in dealing with cumulative and incremental impacts. There was always a lot of concern in Vermont as things were building out that we would one day wake up and say, how did that all happen? And nobody was able to mitigate the impacts. Act 250 was always very conscious of that, and it always encouraged master planning. It always encouraged, planning ahead of time. I remember the era when Sugarbush wanted to significantly expand its lifts and snowmaking capacity, but GMP, Green Mountain Power, had really maxed out its capacity in the valley. But it was good because Act 250 put all those issues on the table, and then the towns in the valley worked with Sugarbush to reduce the demand otherwise required, such that there was additional capacity found for the snowmaking and the lift projects that go ahead. So cumulative incremental impacts, there's a lot of success stories that played under Act 250. There's comments that came up over the years, Act 250 is not good for the economy, or it harms job creation. I kind of look at it the other way, and I point to at least two examples. I forget which recessions these were, but there was one recession that took place, and there was a study done by a university somewhere in the South. I don't know whether it was the University of Georgia, but they looked at land use implications of a recession, and they found that Vermont came through relatively unscathed from that particular recession because it did not overbuild. There was not a glut of condominiums and second homes on the market. It acted perhaps not intentionally, but the outcome was it was a break. And then there was a subsequent recession that took place, and there was a speech given by the president of the Federal Reserve Bank in Boston praising Act 250 and making direct comparisons between how New Hampshire got hammered. The market collapsed in New Hampshire. Vermont came through again relatively unscathed. So yeah, I heard for many years the horror stories of Act 250's adverse effects on the economy. But I dare say there were more positive effects, which continue to this day because of its thorough reviews. So I guess in conclusion, as I already said, It's not a perfect process. I certainly look back over my career and acknowledge mistakes. I mean, I remember one case, a guy wanted to open up a salvage yard, a junkyard, in a town without zoning and subdivision, hired a lawyer, commission even started it off as a minor. The whole neighborhood woke up. And it was very frustrating to watch us go through the process. Again, he was represented by counsel. And I could begin to see this was going to go down and crash and burn. What do I do as a state employee? Do I tell the applicant that you should cut bait because he's represented by counsel? And counsel's encouraging that there's going to be a way through the minefield to get a permit. At the end, the guy never got a permit. He got a $25,000 bill from the attorney. So I feel really bad about that one. But what could I have done differently? I mentioned already the importance of, at least from my perspective, the bright line on jurisdiction. I'd like to see going forward, some sort of consideration of compelling state interest for finite, compelling state interest in trying to sort out new jurisdictional triggers on finite natural resources. I see these finite natural resources as actually important to the economy. Why? Because there's only so many of them left, and as with any commodity, the value is only going to increase. And if we can hang on to them in such a way, particularly in our rural areas, and I think a lot of the Northeast Kingdom, which I love dearly, that this is going to be paid off in spades down the road by preserving those finite natural resources in strategic areas, by maybe bringing them under the permit review so that development is not stopped, but rather it meets the quality development standards of Act 250 and protecting the natural resources. And finally, I'm a strong fan of recreating some sort of citizen board. The phrase is used, professional board, citizen board. I haven't made up my mind whether the model is the PUC or the old environmental board, but it could be better than it is now. I think there's some built-in conflicts in 10 VSA 6028 about the role of the NRB. The NRB, the General Assembly said when it did permit reform in 2005, it said that the NRB, which no longer hears appeals, instead it said the NRB can be a party to each and every case that gets appealed to the environmental court, to the Supreme Court. Nothing wrong with that. The problem is this: it's the same NRB that supervises the district commissions and the district commissions. And there have been instances, increasing instances, where the NRB will contact the coordinator or the commission to say, we are here to help in terms of influencing the outcome of the case. And then the NRB surfaces as a party on appeal. So my point is, the conflict is wearing two different hats. Assisting the decision makers on the commission level as to what that decision is going to be. And then when that same decision is appealed, the NRB is a party, supposedly on the same level playing field with the neighbors or the town or someone else. So anyway, just as an example, I'm not here to dump too much on the NRB, but there are these problems, and I strongly favor NRB. So thank you for listening, and I only live in Barrie. There's hardly anything good on TV. So if I can assist you as your endeavor continues, I'm willing to do drilling down, finding case law, stuff like that.
I just actually, thank you very much. If members are still interested, I'm happy to stay, but it is after 5, so it's up to you. I know there's questions, so. Representative Odie.
I'm going to ask you how you phrase this. You consider compelling state interest to determine what on the state's finite natural resources. So
The finite natural resources, which would be part of the new jurisdictional trigger, would be determined because those specific natural resources are found by the General Assembly to have a compelling state interest.
consider compelling state interest to determine impact on the impact of what it works to say.
Well, I think the bright line is the answer, and it's very simplistic, and I haven't really thought this through, but a good example of a bright line would be, I know the committee is talking 2,000 feet, so bear with me. I favor 1,500 feet. I don't have any technical skills, but I have friends that have been playing around with maps as to where is where are these elevations of 1,500 feet by county, by your districts? I mean, I've dwelt in this building long enough to know that's one of the considerations too. How is it going to affect my constituents? But if it was a bright line, and it's also interesting when you look at those lands above 1,500 feet, how much is publicly owned, state and federal government, how much is privately owned, you can really drill down and be very clear as to what the finite natural resource is. And I'll just give you one example. The amount of land in Vermont above 1,500 feet privately owned is a total of 226,501 acres. That's out of a total of 5.9 million acres in Vermont. So there's 5.9 million acres in Vermont. That huge land mass, the land above 1,500 feet, with the headwaters, the steep slopes, the shallow soils, the habitat areas, the aquifers, there's only 226,501 acres of that stuff.
Who did this for you? Or is it?
I'm a retired bureaucrat, so I don't remember the acronym. It's
BCGO?
Yes.
So but is it the submission we got today, or was it?
You know, years ago, this must be 7 years ago, I was working on something else, I called them up, and it blew me away that 2 days later I got the answer. I was waiting for a bill, I never got a bill. But I do have a letter, I just have this graph here.
And did you send that to me at some point?
I did, yes.
Yeah. So will you submit that?
So,
Will you submit that to Laura so we can all have it?
yes.
Thank you. Representative Fordyce.
Is that between 1,500 and 2,000 feet?
This is 1,500 up to the top of the mountain.
So it's 1,500 and up to 2,500?
No, all the way to the peak.
Camel Stop.
We were told before that there was 500,000 acres between 2,000 and 2,500, I believe.
But he took out publicly owned already.
Yeah, just to be clear, not to mislead, the total amount of land mass in Vermont above 1,500 feet elevation is 855,771 acres. That includes the state, the public, and there's a category here called unknown. I don't know what that means. So 855,000 total, of which 226,000. Just by comparison, how much, if we just use the 2,500 elevation, how much privately owned land above 2,500 feet? 18,519 acres above 2,500 feet. How much all land owned public and private above 2,500 feet? 161,612. So my point is, bright line on jurisdiction, I think, is the way to go. I think the worst outcome would be contested cases just to figure out if somebody needs to get a permit. That would be totally contrary to a Supreme Court decision called In-Re Agency of Administration, which back in late 1980s said that Act 250 was intended to be run in such a way as to not result in an administrative nightmare. The In-Re Agency of Administration case had, by the way, had to do with the building over here, which is known as the Pink Lady, which is now the Joint Fiscal Office. A la that song from Joni Mitchell, they were going to tear that down and build a parking lot. And so the question came up whether that triggered Act 250 decades ago. So that went all the way through the process to the Supremes. I'm going to tell you the answer to that one, but the building's still there, and it did not go through Act 250.
Representative Dolan.
What did you say, how much was publicly owned for properties above 1,500?
Publicly owned land above 1,500. Okay, there's a couple of categories.
Can you say all?
He's going to send us.
Yeah,
Let's not just
My real
take notes on
question-
that. Let's ask some, yeah.
My real question, my more substantive question, is that getting back to process and governance, and you talked about your preference is to see a return of a citizen appellate structure, whereas the information I read this weekend on some of the documents that we have a big binder from the commission, where they described the justification for the change, and it was to create a more quasi-judicial structure to help enhance the decision-making capacity of the board. Can you weigh that kind of the pros and cons, or at least get back to us about what are some of the pros and cons of the current structure had changed to this more quasi-judicial as opposed citizen board. And the reason why I'm asking is that's front and center of what we're worrying about, and again, predictability is an important objective for us while we think through some of these changes. And the sophistication of a quasi-judicial in providing greater predictability is a question of whether that can achieve that outcome.
I'll be glad to get back to more detail. What the nutshell answer would be, the strength of the Environmental Board was basically the beauty of Vermont. You know, it would be, the Environmental Board at all times, in my experience, was such a wonderful spectrum of expertise in Vermont, ranging from farmers, architects, engineer, school teachers, and they would all, 9 of them would put their heads together in light of the existing precedents and figure out whether something met the 10 criteria. And remember, they also had access to legal counsel, because Dean Davis said, on the commission level, do it on that Cracker Barrel in the general store. Worry about legal stuff when it gets to the Environmental Board. So they would definitely be very cognizant of the fact, once the board issued a decision, the next stop on the merry-go-round was the Supreme Court. So the Environmental Board had expertise in terms of subject matter, but it also came up with very thorough legal analyses. On the other side of that coin, you know, one of the unfortunate outcomes of 2005 permit reform on the appeals now going to the Environmental Court is extremely hyper-legalistic. It's hyper-legalistic. I feel so badly, you know, when the salt of the earth, the neighbors want to appeal some case into the Environmental Court, and you really have to mortgage your home, even to get the first base in that court. And you have to go through these Byzantine processes about, you know, party status. If you qualify for party status by the district commission, that's not good enough. You do it all over again before the environmental court. And then you also have to meet, to qualify for standing, the standard of whether you're an aggrieved person. So all these different things pop up. And it really drifts away from the basics of land use regulation. You know, is it the right project in the right place and the impacts? When you read these decisions, it's unnecessarily hyper-legalistic. And it's really in the hands of 2 people, 2 judges. They divide up the workload, and what has been lost over the last 13, 14 years, that wonderful broad experience of those 9 people on the environmental board that would put their heads together and figure out the impacts.
That's a follow-up question? I have a follow-up. But don't you think that we're a much more sophisticated society where decisions and projects are larger in scope or more impactful, requiring a certain level of sophisticated judicial structure? Again, I'm just being devil's advocate.
Yeah. Well, the answer would be 2 answers. One is the environmental board decision prior to its elimination weren't very sophisticated on the land use issues, because they gave us all the great decisions to figure out everything from how do we handle prime ag to aesthetics, so on and so forth. But also they addressed the legal issues that affect a person's property rights and stuff like that. That was all dealt with. And then you still had the recourse of the Supreme Court. The Supreme Court would say, and still says, we give substantial deference, past tense, to the environmental court because they have the expertise in the fact-finding arena. The Supreme Court said we would be happy to re-examine the legal issues. So the point is, where would the emphasis be as you're going up through the process? You know, it should probably remain on the land use impacts, on habitat, on water pollution, on traffic and stuff like that. Because eventually there's going to be other mechanisms of government that will pick up on the legal issues. I think that would be my answer.